Good morning. Good morning, distinguished ladies and gentlemen. I welcome all distinguished members of Alausa. I've already seen some of us joining. I see Mr. Sanuth. Mr. Sanuth, you are welcome. I've also seen a former essay to the governor, Mr. Efo Lasisi. You are welcome, sir. It's good to have you this morning. As we go ahead, we continue to recognize more people as they come in. I've seen Dr. Layeni. You are welcome, ma. I want to welcome everyone. Like we always do, we have a special topic this morning. Before I go ahead to invite our facilitator for today, I would like to apologize on behalf of the head of service and my permanent secretary. They are both at a very crucial meeting as we speak, and so they will not be joining us this morning. Our topic this morning is life in retirement and enhancing your legacy and heritage. And to take us on that topic is one of us, also a retired director, state council. When she comes on board, she will introduce herself properly. I want to also welcome a retired PS, Dr. Mrs. Oduwole. You are welcome, ma. Oh, I also see Mrs. Abidemi Raji. Engineer Adeniyi Abdul has also joined us. You are welcome, sir. Well, as we all know, nobody is going to live forever. It's very important that we determine where all our asset goes when we are no longer here. It's important for us to do a will. If we don't, then we leave it in the hands of government officials, and that may cause strife within the family. And that is why we have an expert in our midst this morning who is going to take us on that topic. We have Mrs. Ayodele Bosedi Bolajoko to take us on that topic, life in retirement and enhancing your legacy and heritage. So, Mrs. Bosedi Bolajoko Ayodele, you have the floor, please. Kindly unmute yourself and go ahead with your presentation.
Good morning, everyone here present. Like Mr. Dorada has mentioned, I'm also one of you, retired, but not tired. I worked with the Lagos State government for 33 years, retiring 8 years ago when I clocked the statutory age of retirement of 60 years. During my working years in the Lagos State government, I virtually worked in all the departments in the Ministry of Justice, which culminated into my becoming the Director of Public Prosecution as the Chief Prosecuting Officer of the state. Apart from that, I also worked in other areas of government. I was also Director Legal in the House of Assembly. And now that I'm retired, I like every other person that will be here today, we are all engaged in one thing or the other. And I think all of us, I believe that all of us have taken our vaccination because it's very important for us to be able to sustain our health and to live well. And it's very important for us to live well whilst we are here, and also, again, to prepare for life when we are gone. There's a reason for this seminar, and I think it's very important and topical. We must understand now that these days, nobody has the time and when one will go back to one's maker. It's common announced, but the best thing for us to do is to be prepared so that when it comes, our dependents, they will not be in any challenges or difficulties, but for them to sustain their life while they're still here. So that is why I want to discuss this topic today, and I believe that it's going to be beneficial for everybody. One of the ways to sustain your heritage and legacy is to ensure that you tidy up. And one of the ways to tidy up is to make a will. It's very advisable to do that, because if you don't do that, then other people that you don't necessarily want to benefit from your inheritance may be the one that will handle it, and the real beneficiary may be left in the dark, and it's not the best. And we've had examples of people that are even expected to know what to do. People who are literate, people who have gone to school, people of means that they never did that. I won't be mentioning names of people, but a lot of us are conscious and aware of some people that left their bounties to the hands of nobody. And sometimes government come in, take the property so that it does not go into ruins and be habitat for miscreants. That's the popular one that we know on the Ikorodu Road, that government intervention had to come in so that the place does not become hidden for armed robbers and what have you not. So it is very important for us to save ourselves, and whatever we have worked for, we must ensure that we keep it, and then we ensure that it is sustained. It is sustained, and it enhances itself, and then it goes to the right people that are supposed to.
On mute.
Okay. I like this is that I've said that nobody lives forever, and we all know it. So it's very important for us to be prepared, and the law has made provision for the mode of distribution of the estate of persons, so that when the unexpected happens, there is a way where the assets are distributed amongst the beneficiary. This is very good because the quarrel that follows when this is not done is not the best. So it is very important for us, first of all, to know exactly what asset we have. We must be able to determine the assets that we have. And I would like to itemize the type. We have money in our bank. We have cars. We have houses. We have jewelry. We have sometimes we know that there's some special jewelry like watches, the Rolex group of watches, all those very expensive watches, and even artwork. There are some people who are lovers of art, and they have it in their kit of assets. So those are the type of things that we are called assets, and those ones we should also understand what we have. Sometimes we even have joint property, or we even have property that are inherited from our parents. So it is very important for us to be able to determine what property we have, so that we will know what exactly we are distributing. So I want to start by telling you what a will is. A will is a document that you prepare which says what you want to be done to your property, your possessions, your belongings. That is what is called your estate. It is called an estate after you go back to your maker. A will is a legal instrument in which an individual knows as a testator, that is, anybody that is drafting the will is called a testator. That testator will have his assets and he will give those assets to people who will benefit from it. They are the ones that are called the beneficiaries. It is also important in our wills to ensure that we nominate what we call executors. These are the people that will be in charge of the distribution of the property that we have. A will is very important because it makes matter easy when we are gone. And it's also ensure that you know exactly who you are giving what to, exactly who you are giving what to, so that there's no problem when it is left on the distributed. There will be coded, this is what I want, this is my own, this is not my own. But when it is in the will, it is specified. Like a house, you can say that this house, my house in Victoria Island, number so and so, I give it to my wife or whoever you want to give it to. You specify the property, the address of the property, the person you are giving the property to, and there must be no ambiguity. It must be very clear and specific, very clear and specific, so that you know the executor will know exactly who and what is being given. Apart from deciding who gets whatever I said, a will can also serve to declare who you wish to become the guardian, especially when you have children who are not of age. You know, sometimes after a while, some people get other children and they may not be of age. So it is important to appoint a guardian that will be in charge of the distribution or take care of those children. When you are making a will, you know, one thing that is funny is that if you ask an average Nigerian if they have made a will, they will most likely get upset and accuse you . Okay, I've been trying to amuse myself. Okay, I hope I don't know whether I have to recap because I had unmuted, but the host wasn't allowing me to unmute. Can I go on?
Go ahead, ma.
Okay. Apparently, the participant did not hear what I was saying. I said that it's not the common place there for people to write their will, and that if you ask a person in a clan whether they have made their will, they probably look at you and wonder, why are you asking me? You want me dead, or what? Why are you saying that? But I think the awareness should come now for us to write our will, especially more so that the times we are in now are very perilous times. A lot of us have seen what has been happening lately. People are just dropping dead without any sickness or whatever. And there's need for us to be prepared. And it is not only when one is old to prepare your will. As it is not the age that matters, it is the concern and the wellness that you have for your dependents. If you are married, it is important to ensure that your wife, husband, or children, especially children and wives, are catered for when you are gone. It is a common knowledge in this our client that when death occurs somehow, it is the belief of our people that the death must have caused by, usually the wife that they make allegation to that she's the one that is in charge, but apparently it is never so. And we are all aware of the fact that sometimes when even people go for burial in the country home, before they are back, some family members will have done the unthought of. They probably will have changed the locks of the house. They probably have done so many things that even when the children and the woman comes, they have nowhere to go. They are thrown into the open. So it will be beneficial for us to be aware that we need to do a will. And because when you do a will, then you specify exactly what you want to be done in respect of your property when you are gone. And Stadia does not cause any rancor, does not cause any ill feeling, because the will be specific of the property and exactly what you want to give to whoever. It's also important for you to ensure that the executor that you will choose to administer your estate must be, of course, must have gotten their consent. There must be a friend, either a very trustworthy friend, a sibling, or even a pastor of your church or your imam, somebody that you have a lot of confidence in, that you know that that behind you when you are gone, you will ensure that everything is put in place. So it is very important that you know the exact executor that you are choosing. If you choose an executor that will not defend your interest, then it may go the other way around. They may connive, they may do a kind of untoward thing. So please ensure that you appoint people that you know are trustworthy, that are sincere, and will do what is right and proper. And you must let them know that you have chosen them as your executor to manage your estate. But sometimes, when a person dies and does not have a will, it's kind of, that is when they say somebody has died intestate. That is, he has not done a will. And in that respect, the settlement of the deceased, that is the man or woman, will now be administered by the administration estate law of the state. The one we have in Lagos State is the current one we have is the administration of estate law of Lagos State 2015. And in that respect, the individual law will now determine what we operate. And in respect of people who are not from Lagos State, the different states in the federation have their own different administration of estate law. So when an individual dies and does not leave a will, the process to administer this estate is known as obtaining probate. By this probate, the court grants the executors who have been appointed under the will the right to administer the estate of the deceased. So when a will is done, the will can either be kept, one, by the testator himself. Usually a lot of people, they have a safe in their house. All those safes that are secured safe, they have fireproof, they have it in their house. You can give a copy for the lawyer that drafted the will. You can now lodge a copy in the probate division of the High Court of the different states where the deceased is resident, and then deposit it. Sometimes you can even deposit in a bank. That we know that the bank have a vault where they keep all kind of things, jewelry and the rest of it. So there are different ways that you can keep your will. So that and sometimes when it's not out of the ordinary, to let people, even your children know that I've done my will, and it is in the particular custody. So that at the end of the funeral, when everything is done, they can now, through the lawyer that drafted the will, they can now go to the probate division of the High Court. That is where they will invite them. All of them will go together there with their lawyer, and the will be sealed. The will will be sealed. It's not an open thing. It will be sealed, wax. It's in their presence that the envelope will be opened, and then the will be read to all the parties that are there. So it is important to let you know how a will is done. A will must be in writing, must be in written form. There used to be what they call oral will, but that one is not really the best. Because if it is oral, then how do you keep it? Well, these days with electronic devices, I think that with that electronic device, it will be better to add it to the written form, just to corroborate whatever you have put in written form. So a will must be in writing. And also, anybody that must write a will must be an adult above the age of 18. Above the age of 18. And earlier on, I said that we do not have to wait till we are 70 or 60 to write our will. As a matter of fact, ideally, it is better as soon as you have clocked the age of 40, write a will of whatever you have. And as you progress in life, as you get property and the like, you can also always amend your will to add your additional possession to whatever you have gotten. And these days, people are doing very well. We have people who are 35, 40, and have done very well with themselves. They have a lot of means. So they will not say that it's only when I'm 67 that I'll write my will. Write your will as soon as you know you have some things that you have some possession that you can give out. And even in writing a will, like I rightly said, it's always very good to write the name of your beneficiary in your will, the name of your children, whoever you want to give, your children, your wife, your children, and maybe even you can give your mosque, your churches, your society that you belong to, like the the Guys Guide, the orphanage homes, or all the rest of them. All those ones must be listed in your will. And it is important to list names of your children, because sometimes we know that well, that's why I want to advise the men. We know that some men have children outside of wedlock. If you don't put the names of these children in your will, they will be disinherited. There's no way that they will be a part of that will, unless you have done the needful for them without capturing them in your will. But if you want to capture them in your will, you have to list them as your children. Because we are all very familiar of what people call funeral children. It is when a deceased dies at the burial ground that people begin to see all kinds of children coming and saying that we have come to bury our father. And usually there's always trouble. We know it. You see people arguing on burial grounds that you cannot pour dust to dust, you cannot do anything. So to prevent all these things, please ensure that all your beneficiaries, particularly children, I don't know about wives, but if you are not, if you did not marry in the statutory way, you can list the number of your children. But you should know how to plan yourself. But so you don't do it to write. It is very important for one to be specific of who and what one is giving. You must put the full names of whoever you are giving your bounties to. I give my land at number 12, Olaiya Street, Victoria Island, to my wife, Mrs. Adeola Elizabeth, your name. Not, I give my wife, Mrs. your name. Be specific and direct so that there's no ambiguity about it. And also your children too. Be specific about what you are giving your children. I give my daughter, Bimbola Olushola, if she's married, her marital name, so and so. My son, Victor Adeolu, blah, blah, blah. My house at number 45, Parkview Estate, Ikoyi, or wherever that property is domiciled. You must be specific of the person you are giving and the property that you are giving. And the will must be in the presence of 2 witnesses who must sign joint when everybody is there. It is not that one is signing and the other person maybe runs downstairs to do something or comes back later. It must be at the same time that the 2 witnesses are signing the document. Because this is very important, because if there's any lapse in all these things, it will be rendered, that will be rendered invalid and it goes to no effect. So we must ensure that we do this will drafting with the rules and regulations that goes along with it. And then we must also express there that you are writing the will as a free will, free with your own freeness, with freedom, not that you are being cajoled forcibly to do your will. You must say that you are writing your will by yourself, by your own freeness, not that you are being forced or cajoled to write your will.
Next slide.
Next slide. I've already explained that an executor is somebody you trust, that will be responsible, that will work behind your back to ensure that everything is carried out. And then when you do your will, the executors are responsible to pay all debts that has accrued. Debts like maybe you borrow money from some people, or maybe even some people have borrowed money from you and they return the money when you are gone. Some people have conscience. If they borrow money from you and they know you are gone, they will come and say, this man has borrowed me certain amount of money, I'm returning it. And if at all there's any debt, the testator himself must have specified, because funny people can just come and say they are owing. So even the testator will not specify, because you know there are some long-term debts. I have borrowed so amount from the bank, so amount, and so that the debt you are owing must be stated, so that funny people do not come and say that you are owing them. And then the executor is expected to show utmost honesty, diligence, and good faith in their duties to you, to your estate as your executor. It is important to note that the testator cannot name, you can name, like I said, people that can be your executor must be a trusted friend. I say a trusted, friendly friend, not somebody that you do not trust or you do not know their capacity to ask for you in good faith. You can also choose a relative. There's no harm in that. You can choose your sister, you can choose your brother, a cousin, or whoever that is your blood relation to also be your executor. And though, in order to not to complicate it is important to ensure that the lawyer that you will get to draft this your will must be somebody that is diligent, that has financial expertise, and knows what to do to ensure that the will that they are drafting is such one that is valid and will not be challenged and thrown away in the court for some lapses. Okay, well, again, sometimes a will can be contested when, like I said, it was not properly signed by the witnesses, the minimum of 2 witnesses, or the property in the will was not specified, or the beneficiaries are not known, or whether there is an argument that the will was done when the person do not have capacity. Maybe they say that the person has been very sick and he does not understand what he's doing. If it can be proved in the law court that the person who drafted the will, at the time of drafting the will, was not in the topmost form, then that can be a basis for challenging the will. And if it is proved, the will can be rendered invalid. I have mentioned that
should change the slide.
Next slide.
Right.
Yes, I have said that it's like it's a challenge when it's difficult for me to unmute. I keep on unmuting and it's not going. Yes, I've said that a will can be contested if there's any lapses that has been suspected to have happened. For instance, if there's evidence that the person who drafted the testator, that is the person who drafted the will, was sick to the point that as at the time of sickness, when the will was purported to have done, the man somehow mental state was not stable. That can be a ground for the challenge of the will. There can also be a challenge of the will if there are some lapses in the will, where the will was not signed by one of the 2 witnesses, or when there's reason for people to believe that something not proper has been done on that will. And we have examples of wills that have been contested in this country. Very prominent Nigerians whose will have been contested. Even as we speak today, there's a former minister of years whose estate, family matter has been in court. This was a minister that was won during the Tafawa Balewa era. That case is still in court today because the will was contested. So it is, and then when a will is contested, you will know that all those property, they will go into ruins. A lot of those property will go into ruins. So it is very important that we get a very competent lawyer that will know the nitty-gritty and will not allow any lapse to be in any of the will. And again, like I said, the will must be signed, it must be dated, it must be specific, it must be said to have been done without any force or coercion. So when that is done, we will ensure that there will be no need for any litigation to hold on to the property, and the property will go into. I will even mention it. The matter I talked about the one-time minister in this country is the case of Okotie-Eboh, who was the then Minister of Finance. You can imagine Chief Okotie-Eboh that had died many years back. His will is still being contested till today, and there's not been an end to it. One appeal against the other has still been going on. Instead of that, you can imagine all the property that the man has all over the places. Those property, you can be sure, because once the matter is in court, then you are stopped from having anything to do with the property. Even the money in the bank, you can even understand that one, the money in the bank. But all the real assets, the houses and the cars and all of that, you can see some pictures. You see some limousines that are parked somewhere that are rotting away. Those are the kind of will that have been challenged. But you know, even you all know what happened in that Ikorodu Road, the Kaban Bamboo property. Until the Lagos State government came to the rescue, that place the property became a squalor. All kinds of miscreants were just doing rubbish on that property. Peradventure, if a proper will had been done, and the place had even been given to a trustee to manage. Some people may even give their property to trustees to manage for them. I will quote an example. Chief Gani Fayoemi, when he died, he gave his estate to the First Bank trustee to manage for him. And that has not caused any rancor or anything, because that one will be properly managed and there will be no quarrel among the family members. But when a man who, for one reason or the other, has not done a will, and it is very prevalent and very common in our country today, that people believe that if I do a will, then it's like I want to go beyond. But that is not the case. You can do your will, like I said, as early as when you are 40 years old, or even less, so long as you have tangible things that you know you have, that you do not want to go into waste, you want to bequeath to other people when you are gone. So it is very important. And I've said that the assets that I will name it again, things that we call assets, your money in your bank, not your retirement fund that is logged with your pension managers, because that one cannot be put in your will. Because you all remember that in that, while signing that form, we had named our beneficiary in our trust in our retirement savings account with our pension manager. But your own personal money that you have in your bank account, that one you can give to your beneficiary. There are cards too that you can give. There are land that you have not even developed that you can give to your beneficiary. What of jewelry? Women, you know, a lot of women, they have all this jewelry and all of it. You can have a way of disposing of them by saying, you name them, you name your whoever you want to give, your daughters-in-law, and even your sister or any of your siblings. You must be able to name specific things you want to give to your beneficiary. And in writing a will, you have to start by saying that, because, like I said, you can begin to update your will from time to time as you acquire new property and things. You always amend your will. So every time You must always have it in your mind that you start your will by saying, this is the last will and testament of me, but your name, your address, and then the town, the state, and the country. Paragraph 1 of the will will say that any previous will that you have made are cancelled. Example, I hereby cancel all previous will I have made of every nature and kind whatsoever. Paragraph 2 will say, I appoint two persons who will look after my affairs after I am gone. These are executors. You will name them Reverend so and so. 1, 2, whether your sister, and the name of your sister, the address of your sister, you will write it there. Example, I appoint my brother Ademola Eze Yakubu, and my dear friend, Mr. or Mrs., the name of your friend or whatever, to look after my estate, and hereinafter refer to them as my executors. The next paragraph will say that what you want done with your property. Example, 1, I direct my executor, that is the 2 names, to pay all my debts. One of the debts that you need to pay is whatever debt you are owing. And sometimes it is stated that the funeral expense, but usually it's always better not to put your funeral expenses in your will, because of course it will not be immediately you die that your will be read, because they have to do all the preparation, doing family meeting, arranging for your burial and all of that. So for good accounting, you can easily instruct your bank, that your bank manager is stating to your bank that as soon as, and you give information to your wife and children, whatever, your children or your wife, that I have instructed my bank to give you some amount of money for my burial. That will not be in the will, because time will have overtaken that, because a will cannot be read before death, it is after death. So to ensure that you have a befitting burial, it will be wise of you to instruct your bank manager that as soon as they get information of my death, so amount should be released to my wife and children for my burial expenses. If you want to give a special gift to any of your children, like we all have special things. We have the general wristwatches and the very expensive one. For instance, I give my Rolex wristwatch to my son, the name of your son, address, and all of that. And if you want to give something to your grandson, for instance, you can expressly say there that I give to my grandson the name on his graduation in the university. It is important to express the graduation you are talking about, because you know that these days, even nursery school, they do graduation. You see nursery, small children wearing graduation of the University of Lagos. On graduation, my Toyota Camry specify the registration number. There must be some problem. So it must be clear, concern property that is left over after all the listed items have been disbursed. Because like I said, you must list the items that you have. Your house in Victoria Island, in Ikeja, Lekki, Bagada, or wherever. And even your country home, in Ekwe, Badagry, or any other country home in any state of the federation. You will specify what exactly you want it to do. Usually, what happens is that the country home is never really allocated to anybody. Usually said that it will be used as by the members of the family, the country home where they are domiciled. It is only properties that are in the towns that usually are given individually to different beneficiaries. So it's not wise to give a family property, your property your country home to a particular child, because one time or the other, they may need to do family events and all of them will stay in that family property. Then again, it's very important that the last paragraphs of the will must contain the statement as follows, that I signed this will. You must, another important thing about the will is the number of pages of your will must be known. And again, it is also better to sign all the pages of that paper document, and also the witnesses too must sign, so as to prevent any removal or addition to that will. So the will must be, you must know the number, you must have said no one is removed and is attached. There's what we call, can you, okay, like I've said that there is an additional clause that you can put in your will, especially for children. Under the age of 18, who do not have, who are to benefit to hold whatever gifts you want to give to them, because they are minor. In law, they are not expected to be able to do a lot of things on their own, although children of today are wiser than we think. So usually what they do is that they appoint a guardian for them. The guardian can be a family member, or a friend, who will look after those children for underage, will be the ones that will be responsible. Usually what they do is, you see, when you have children under the age of 18, especially the very young ones, they are usually put in the homes of family members, sisters or brothers, to look after them. Their schooling, their everything and all of that. So that will be so. Because and then whatever you are even giving them, they will not be able to appropriate it until they reach the age of maturity. So from all that I've said, from I have from what you have heard this morning, I think it is important for us to have a rethink. If we have not done our will, I wonder how many of the participants that you can give to your children. At least I know that we have everybody will have at least one property to give and whatever. So sometimes we may even say that property should be sold and the money. Okay, in conclusion, from all that my people have heard this morning, I think you will have seen that sharing the estates of a person who dies without a will will most likely run into controversies. So we should therefore, as much as possible, try to avoid that by either proceeding to write our will if we have not done so. And I'm too sure that a lot of us that have participated in this presentation, in this presentation, are not likely to have done their will. But I want to encourage all of us to, as quickly as possible, write our will. There's no law that says a lawyer should do your will for you, but it's advisable that you get a lawyer to draft it for you, so that there are no errors that will render that will invalid if there's any need for them to go to court. I wish all of you, my brothers and sisters, my colleagues and friends, a happy retirement life, and that we continue to enjoy ourselves, be healthy, and then be prepared. It's very important for us to be prepared because we never can tell when the Lord will call us home. I wish everybody the very best. God bless you all. Thank
you very much, man, for that.
I'm available for questions and questions. There are any clarification that you want me to do, I will gladly do it. Thank you.
Thank you very much for that beautiful presentation. We are very happy to have you. While the webinar was going on, the 20th head of service joined us, Mrs. Adesoye, Mrs. Folashade Adesoye. You are welcome. And Mrs. Oguntuwashetu also joined us, a retired permanent secretary and a former honorable commissioner in the state. She also joined us. And I think she would like to make a contribution. I can see that she signified, so I'm going to invite her to make a contribution or ask her question. Please unmute, ma. Unmute yourself, ma.
Hello.
Yes, you are audible now.
Okay, good morning, everybody.
Good morning, ma.
The presenter, èèyàn mi ni o, káàárọ̀ o, bọ́sẹ̀ ṣe dáadáa ni.
Máa ìyàwó, máa ìyàwó.
Ìyàwó, ìyá akọ tí òkè fún ìyàwó ẹ̀ lówó oúnjẹ.
Tójú ẹ̀ ń tán báyìí.
That was a beautiful presentation. Thank you very much. I have one or two questions. Number one, can we change lawyers in between having wills? Like I have a will that I made many years ago, and it's about time I updated it. However, my lawyer has relocated, and I'm kind of in a limbo as to whether I should continue with somebody that is not on ground or I should take a new lawyer. So please throw light on that. That doesn't necessarily mean that the person who starts it, the process must conclude it. That's one question. The second question is that I'm an executor to a will, and that will has been contested. We have been in court for almost 80 years now with all kinds of issues coming up from the people, the people who took us to court. The deceased had no children, and she was a lawyer. She willed her property to whoever she wanted, but the family is contesting it, that in their culture, whatever she had belonged to them. So they are saying that she couldn't have written that will. But the more worrisome aspect of it is that this matter has been in court for so long. Okay. The properties are just there, rotting away, and we have no idea when this will come to an end. Unfortunately, the case file got burnt with the Lagos High Court incident last year. So we had to start all over again. So I'm just asking, why does it take so long for the court process to be concluded in matters of will? Thank you very much.
Okay. Yes, let me start first by telling my Mrs. Mudukwe that will that was originally done was signed by 2 witnesses, right?
Yes.
So now that your lawyer is outside of jurisdiction, the best thing that the option you have now and the best is that you do a new will with a new lawyer, because that document on the face of it, the lawyer who is no longer here cannot do anything on that will without the presence of those 2 that were the original witnesses. So what the best thing to do now is to do a new will. We already have a copy of this, so just incorporate all that you have, and then the additional thing that we've gotten, and then do a proper will with a new lawyer on ground here in the country, and then we could also get use those 2 witnesses or get another 2 witnesses. But you cannot, because already signed by that lawyer and the other 2 witnesses that you have gotten. So it's not a big deal. All you need to do is just transcribe the information on that original thing, put your additional bounties into it, get new witnesses, all the previous witnesses, and do a new will. That's the one that's best for you.
Thank you.
Yes. Then, as regard the one that you are an executor, and then the will is being contested, and then the testator died without an issue, and some people have gone to court to challenge the will. I wonder on what ground it was challenged. I don't know, but the difficulty about that now is that even to start de novo is now a challenge, because I hope it is not that lawyer that drafted your will that is handing this brief, because if it's the lawyer that's handing the brief, he must have some document in his own custody with the file he has. So that would be easier. But you see, these things about litigation is not always the best. That is why it is very important for us to ensure that when we draft, because like I mentioned in my presentation, that Chief Okotie-Eboh, Minister of the First Republic, his will is still contested in litigation till today. You can imagine when Chief Okotie-Eboh died, and the fact that the estate is still in court till today. So it's always very protected. It's always it's so sad, and you know, our people, any little thing they are appealing, they are doing all kind of things. So that is why it is advisable that you do a good job on your will, and essentially I think, you see, let me give a little information about the Chief Okotie-Eboh's will. Chief Okotie-Eboh has a daughter who is supposed of a legal marriage, and then the man had other children outside of wedlock. So the only child of the marriage was now claiming the estate of his father, saying that she's the only full beneficiary of Chief Okotie-Eboh's assets. And but that is the law. She's the daughter of the legal marriage. The man had not done the needful. When he knew that he had all these other children, what he needed to have done was to have given them their own share inter vivos. While he was alive, he should have given them XYZ. I give you my house in Sapele, this and this. I give my house in Victoria Island, this and that. So you don't have warranted. Of course, the lady was right. The daughter that is the legal child of the statutory marriage, she's right. But you know now, you continue to contest. Especially, of course, everybody knows. As a matter of fact, I knew about the case because I was in court one day when the matter was still in the High Court, and I saw those children that are saying that they look like the mom so much, even more than even the one that is in claiming. So you see all these things that men should be very careful about. And you know, like I said, all the man's estate has gone into ruins. Like even you have by mistake, because you have observed that the estate that you are the executor, the estate has gone into ruins. So where do we go from there? It is very important for us to ensure.
The question, Bose, is that
yes,
what can the courts do to expedite? You see, in this particular case in which I'm an executor,
yes,
the point these people are bringing up,
yes,
are things I'm a layperson that should have been dismissed because the deceased was a lawyer.
yes,
she knew what she wanted.
yes.
And they are coming up with all kinds of things that, you see, the thing is that the courts don't sit regularly, for starters. Second, the judges are being changed from time to time. And the interest of the common man is not put into all these things, especially when there is merit. Do you understand? So the courts themselves must do something that, given the nature of this thing, it must be disposed of within a specified period.
No, let me,
you say.
you say, okay, the thing is, now we have a divisions in the court. We have the family division now. So I believe that things will be much better than what it used to be. Now we have a family court where issues like all those can be addressed. And of course, you know that when it comes to issue like that, you must hear the two sides of the matter. You cannot say you are hearing one side and another side you are not hearing. And you know all these antics. Today, there's one thing or the other. Even the court may not be functional. This and all blah, blah, blah may not be working. The witness or whoever might be ill. There's all kind of excuses come all around. What can one do? The thing is, in this particular matter, I don't know the full fact of the case, but the lawyer on the other side can also bring an application for accelerated hearing. I think why this one is lapsing is because the testator did not have a child. You can imagine if the testator has children and they are still in the university and they need to pay fees for their education. Of course, something will have been done. They will have brought an application that at least that the court should rule that part of the estate should be disbursed so that the children can go to school. I think that is why this one is taking so long, because there's sincerely no direct beneficiary like that in this matter. And then I don't know, maybe you see me in camera, I can advise you as what to do in regards of this your matter. That's the little I can say.
All right, thank you.
So that's your will. This, my dear, do a new one. Just translate everything in that old will. Put it in a new one. Add your additional bounties. Get new witnesses or the earlier witnesses, and then you are good to go. And you are good to go.
Thank you very much, Mrs. Ayodele. And I hope our former Honorable Commissioner is satisfied with that response.
Yeah, all right, thank you.
Thank you, Master. Let's take, we have a former director and also a former SA to the governor on taxation. He's also raising his hand. Please unmute, sir, and ask your question, Mr. F. Lasisi.
Thank you, Ms. Rose.
You're welcome, sir.
The presenter, Mrs. Ayodele. That was the next one, except for the technical glitch. It was well put together. Thank you. I have two questions. The first question, ma.
Yes, sir.
If the level of dishonesty, betrayal in our society these days is to go, is it possible to make the jury or some of the executors of
I didn't get that, sir.
Please, can you type your question, sir?
Yes.
You are not very clear.
Okay.
Yes,
sir. Yes.
Can it make?
Your bandwidth is very low, so we are not hearing properly. Can you type your question, sir? I think it's better you type.
Okay.
Type your question while we take Mr. Daudu. Mr. Daudu, please, can you unmute and ask your question? Please unmute, Mr. Daudu. Okay.
Yes.
Mr. Daudu is a retired permanent secretary. We are glad to have you, sir. Please unmute. Please unmute, sir.
Okay, thank you.
You're welcome, sir.
Yes, I want to thank Mrs. Ayodele for this good presentation. I just want to ask, if one has done a will and he has, out of those properties, he has sold part of it, what can we do again? Sold that part of the property listed in the will. So what is the next thing to do? Can we rewrite the will all over?
No, yeah, okay, no. what you need to do is, like, we have amendments. That's what we call codicil. We call it codicil. Yes, so you can write additional in that amendment. My property, XYZ, Parkview Estate or wherever, have since been sold out. So it is no longer part of the asset to be shared by my beneficiary. Just an amendment to the will.
Okay.
And if you have acquired a new one after you have done that, you can also update that. Maybe when you sold the one in Parkview, you now have gone to buy another one in Banana Island. You can now add that to your as an amendment to your will.
Okay, thank you.
Yes, welcome.
Thank you. I want to lower my hand.
So, Mr. Lasisi did not type any question. He didn't type his question.
Okay, maybe he can come again when I can hear him.
Okay.
He was talking about testator or something like that.
Okay, Mr. Lasisi, please, can you come up again? I think he left.
Okay.
We have Mr. Akim Tairu, who would like to contribute as well. Please, Mr. Akim Tairu, can you unmute and make your contribution?
Thank you very much, Mrs. Dodola. And I want to appreciate the presenter for the thought-provoking paper presentation. Actually, at this hour, this is the kind of thing we need to know. So the clarification I want to make, or I want you to educate, is under the law, is it possible for an executor to be a beneficiary? That is, if it is allowed that the testator can include it. And if not, does the executor stand to gain anything by way of a fee for doing that, or the law allows the testator to give something in return for doing that when he passes on? Thank you.
Okay, yeah. Mr. Tairu, first of all, you cannot, you're asking that whether
an executor can be a beneficiary under the law. Is it allowed?
Whether an executor can be a beneficiary.
Yes.
Yes, I don't. No. All that the executor can have is like a fees. He cannot be a judge in his own cause. He cannot be there listening to what. No, first of all, the executor not necessarily will be there, but the man, the testator,
yes,
will have informed him. Yes, will have informed him that he's going to be one of these executors. There's nothing wrong. The only persons that cannot be a beneficiary in that will are the witnesses. The testator can give part of his bounty to the executor, because sometimes the executor can be a family member. One of the executors can be his brother or sister or cousin. So usually, as a matter of fact, because oftentimes people normally use one of the executors as their blood relation, and they appropriate some of their bounties to them. So it is okay. It is allowed for a testator to apportion some of his property to any of the executors.
And also,
are you clear?
Yes, the second part is that if that does not exist, and is there anything that is paid to the executor for the job done when you decease the person?
If usually the man who is sharing his property, the testator, he can also give money. He may not give the executor real a gift like land or house or whatever, he can say,
Yes.
my executrix, the woman is the executrix, is now giving maybe 200,000 cash. That can be done.
Yes.
Is entitled. The idea is that is entitled to part of the benefit, part of the property or possession of the testator. That is just, it's clear. It's only the witnesses that are joint, that will be there when they are signed, where they are preparing the document and signing it, that cannot be a beneficiary.
Yes.
Is it clear now? The witnesses
Yes,
to the will
very clear.
cannot be a beneficiary, but the executor or executrix can be a beneficiary.
Well done. Thank you very much, ma.
Okay, thank you very much, ma. I also want to recognize a retired permanent secretary and present chairman of Audit Commission, Mrs. Onikoyi. You are welcome, ma. And then we also have with us former GM LASRA, Mrs. Kemi Adelusi. You are welcome, ma. So now we go ahead to take the contribution of Dr. Mrs. Oduwole. Please unmute, ma, and make your contribution.
Hello.
Yes, you are audible, ma.
Oh, thank you very much. Thank you for this very good presentation. May God continue to help each and every one of us.
Amen.
Please, I have a question to ask Mrs. Ayodele. I have seen families saying that others are suffering while one person will be taking all the money, everything, all the largesse in the will of great men. Please, can you enlighten us what causes this? Because I know a particular family that the others are suffering so much. And is it a case of bullying or whatever? I don't understand. What could have caused that? Thank you very much.
Yes. First of all, it must be that the will, the purported will, was not logged at the appropriate quarters. That is the probate division of the High Court.
Okay.
That must have been the reason. Otherwise, if the will had been logged in the probate division of the High Court, the lawyer who drafted the will, unless he's colluding, the lawyer who drafted the will have advised the family that your father has a will, and the will has been logged at the High Court of the state. And then the necessary timing will be gotten, and the whole family will be invited to come to the court. It is in the court place, the probate section of the High Court, that the content of that will be read to all the beneficiaries or anybody interested in that will. So it must have been that the will was not logged in the appropriate place, and then it was not proven. Because ordinarily, everybody will sit down, be like a conference. Everybody will sit down in the probate with the probate registrar, who will read the context of the will. As a matter of fact, the will be opened in their presence, sealed. They will remove the something and then read to everybody in the room. And then they're even entitled to go with their lawyer when the will is being read. So I don't know what has happened in that situation. Obviously, the will was not logged in the appropriate place. So it has not taken the effect of law. That is where the other ones are being marginalized in the sharing of the bounties of their father or mother or whatever, whoever it was. That must have been the reason.
What is the way forward? Some of them have started dying, you know.
You see now, obviously, it must have been all these politicians that have money or industrialists that are well off and all of that, and did not tidy up. That's just the essence. Or we have situation whereby we have the matrimonial, the legal wife.
The legal wife.
Yeah, the legal wife. You know, we know women now. You know us now, women. Women, I'm the legal now, so all these other ones. It's just that we didn't bring anything to this world, and we're not going away with anything. So we should be magnanimous. What will happen to the man that even has all the bounties? He has gone and left everything. So we should kind of, I know families that the man was a politician, a well-read man who had a legal wife and had children all over the place. the head of the family, the first daughter, I won't go further. She was magnanimous, even being a person of the law. She was able to carry all the children along, educated them. Of the fact that she said, how can this one be bearing my father's name? And they live and they behave somewhere. They're not educated, they're living in penury. No. It's unacceptable to me. That's why the fact that her mother did not even want her to do that, but she just talked to her and said she must train her father's children, so long as she believes and knows that they are her father's children. And she does not want only them to be beneficiary of the man's huge estate. These ones that are bearing her father's name, they must not live in penury. Otherwise, it will be shame on the family. So I think maybe they need the counseling. They need to let them know that so I think they need some talking to and counseling. That's the only way. Because they obviously the will was not logged in a appropriate place. That is why that has happened. Yeah. That is why.
Thank you.
Yes. So that's why we should ensure that when we prepare a will, it should be also logged in the High Court. That is where the will be read and then it will take the effect of law. If they do not log it there and they do it, or maybe by adventure, they even did, like I said, the will can be logged in all these other places. Maybe they logged it in the house of one of a trusted friend, and that one, people are kind of somehow not ready to fall fight against the law. They would rather be more comfortable to ensure that they comply with the law other than maybe a friend of their father or anybody wanting to prove one will. So it is important that the will is logged in the High Court. It will take the force of law.
Do we have any more questions? I can see that Mr. Lasisi is just coming back. Former Estate Governor on Taxation. I think he's back. Please, Mr. Lasisi, can you go ahead with your question? You can unmute, Mr. Lasisi, and go ahead with your question, sir. Unmute, sir, and go ahead.
Okay. Yes. Can I go ahead now?
Yes.
Go ahead, sir.
So I have two questions, ma.
Yes.
Number one, if the level of dishonesty and betrayal in our society is anything to go by, is it possible the beneficiaries, the executors of my will,
It's muted. It's muted, I guess. You should repeat his question.
I can't hear.
I've sent one question. I've sent one.
I can't hear. Mr. Lasisi, I can't hear. I didn't hear.
Okay, send
Oh,
it.
okay. Okay.
I've sent it that.
Right.
Okay, hold on. So this is. Okay, come on, let's check. Okay. Is there any financial implication?
Oh, yes, Mr. Oh, this is from Mrs. Is it Mrs. Johnson?
Yeah.
There's one Mrs. Johnson. Yes. Yes, Mrs. Johnson. Yes, you have to. It's when you lodge a will in the custody of the High Court. Of course, they will not do it for free because it's a duty they are rendering to you. It's a service and you must pay for it. Just like when you put your box of jewelry in the bank to keep for you, there are fees that you need to pay. So I'm sure it's not one that will be too much for you, especially when you know the benefit of why you are lodging it in the safe custody of the High Court. And then especially the benefit of it, like I've said, if it is lodged in the High Court, it attaches much weight than being lodged in any other place, like even in the office of the lawyer or even in the hand of the pastor or an imam and all of that. So it's a service rendered and fees are attached to it. Okay, Mrs. Adebuji, you said that 4 of your siblings are executors of your will and beneficiaries as well. Yes, there's no, like I rightly said, the only person that cannot be a beneficiary of the will is the two witnesses. Usually, the executors of will are oftentimes family members. It's occasionally that you have friends or religious persons. Most times, they are blood relations. Your children, your wife, and even in homes that you have more than one wife, they'll take the wife naturally, and then maybe one of the diggies will be part of the executors, but it should not be more than 4. You don't want anything to be that unworthy. So maximum of 4, a minimum of 2. Yes, Mr. Latisi. Yes, Mr. Latisi, sir. Yes, it's even better. It's even better because it's better to trust your things in the hand of your blood relation than to trust it in the hand of outsiders. Oftentimes, is your blood relation that they use as executors of will, but maybe not necessarily the children, but your brother or your sister. Usually, to make it kind of neutral. Can you get Mr.
Yes, I do.
Usually better, sir. It's usually better to use your siblings. It's usually better to use your siblings as your wife and your siblings, because if you choose any of the children, it's like you are preferring one than the other. So it's to be on the safe side, better your wife and your sister, brother, or cousin, or somebody of age, somebody that must be above 18, must be of age to be your executor. Usually, people use their blood relation, which is better because they are an interested party, so they'll be ensured to manage it better than to use an outsider to be your executor. So it is advisable. Okay, sorry, Mr. Yemi Johnson. I'm sorry. I hope Mr. Yemi Johnson Ogunleye. Okay. I hope I've answered your question. Yes, that you can make beneficiary is even better than to use an outsider, because it's an interested party and it will ensure that all is well. Yes, financial, of course, is a service render. When you when you get a service, you pay for it, just like any other service that you get. Is that okay, everybody? Have I answered your questions? Is there any other one?
I think we have one more hand that is up. We
Okay.
have Mrs. Olabode Tylat Ajao. You
Okay.
can unmute, man, ask your question. Please unmute. Okay.
This is Mr. Alabode Ajano, Mrs.
Mr. Sorry.
Mr. Sorry. We
Mr.
don't want to
Alabode.
turn you. We don't want to turn you to a woman. You know, you're
Good,
not.
good afternoon, everyone.
Good afternoon.
Good afternoon, Mrs. Ayodele,
Good afternoon, sir.
and our able presenter, Mrs. Ayodele.
Thank you very much.
It has been a very interesting and educative presentation.
Thank you, sir.
We appreciate your presentation.
Thank you, sir.
My question is, having picked your executor to the will, two
Yes,
of
sir.
them, I believe, if by chance, before the execution of the will, one of them dies, what happened to the will? Does it invalidate that will?
Where we usually, until now, when things have gone, when the usual are now happening, usually people that draft their will, they usually pick people much younger than them, that they expect their life expectancy to be longer than the testator. But if that happens, then whatever challenge that is there, there must always be a solution. So if that happens and the person picks only two, and then the will is now read and proven, I think the best thing that will happen is that the parties, the beneficiaries, can agree amongst themselves as to who they would like as a replacement. And then they'll give them option. Choose either a family member, another friend of your mom or your dad, or your pastor or your imam, as the case may be. Because it's better to have minimum of two, because I mean, to be advisable to have more than two, and in the sense that there will be need for fairness, so that it's not tilted in one side. That is why they said minimum of two, so that the two of them will agree to agree. Now, if that happens, which can happen anyway, the beneficiary of the estate, with the lawyer that drafted it, we pray that the lawyer has not relocated or has even passed on. But in the wisdom of everybody, the probate registrar in court will now tell the beneficiary when that is noticed. But of course, when they open the will and they see the name of the executor, the beneficiary will know, this our uncle has passed on. You know what I mean? Then the onus will be on them now to choose who amongst all of you are you agreeing to be a replacement to oversee the assets of your father. So when the meeting of minds, they will agree on one person, and then they'll be good to go. That's the only rationale, because I know one person can, it may even be an odious thing. Especially also if the man is a man of means. And it depends on even the context of the will. It depends on the content of instruction that may be coming from the asset that is going to be distributed. It depends, because for instance, if somebody has an estate, for instance, and they need to collect, depending on what is in the will, they need to collect rent and all of that to ensure that the rent is shared among the children. It will not be easy for one person to do all those running around and all of that. So it depends on the content, but minimum of two. So the best thing is that when they put it to the information of the probate registrar, that this auntie of ours or this cousin or whatever is no longer alive, then they will be directed to, amongst themselves, choose who they think will be able to stand in place of that man, who particularly will be a person who will be able to manage the asset in a way that we know, we have also said will be diligent will not be partial and all of that in that thing. So that is the way to go about it. There must be a meeting of minds and to be directed by the public register of the court where the will is being read.
For any reason.
Thank you very much for the explanation.
Mr. Fatai assistant, yes. As much as when you get new things, sir, you can amend. You begin to amend at any time. Yes. When you get don't know, you might even get a windfall, a lottery, and there's so much money, and then you buy another property. You now put it. This is an additional property I've acquired. So I add it to my asset. So you can do codicil. There's no limitation to the number of codicil that you can do.
Okay. Would that be all, Mr. Lasisi? Would that be all, sir? Please unmute.
I think it's all.
Okay. At the time
I'm okay. I'm fine. I'm fine. Thank you.
Okay.
That's all for now.
Okay. You're welcome, sir. The time is fast spent. I think we can draw the curtain on this program for today. I want somebody to, on behalf of the retirees, appreciate Mrs. Ayodele for this beautiful presentation. Let's have someone to appreciate her. Okay, can you do that for us, Mr. Lasisi?
Okay, why not? Yes, on behalf of all the especially the participants to this webinar, ably anchored by Ms. Bose Ayodele, I'd like to express appreciation, profound appreciation for a well put together paper and the lecture beneficial for us. I must thank Drew Dollar and the technical team for handling the fine details of this program and making it essentially helpful. Thank you. God bless. We look forward to more of this.
So thank you very much, sir, Mr. Ayodele, and thank you, Mrs. Bose Ayodele. We are so glad to have you. Retirees webinar is usually bi-monthly, one on health and the second one on our finances. In another 2 weeks, we are going to have another one. I'm going to unmute everyone now so that at least I'm sure you will see one person you have not seen in the last 1 or 2 years that you can just say, let's make it interactive before we finally draw the curtain for today. So I have unmuted everyone. You can all unmute.
Yeah, well,
We have another
bye.
September.
Bless. Love you all. Love you all.
Bye bye.
Love you all. Love you all.
Thank you. God bless.
Thank you.
Raymond Ogunbolaji from London.